In the closed session this morning, I indicated to you I am going to be entering an order requiring the retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you.
I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host Pavarotti, and I am here to discuss the IDAHO4 case. And in this first video today, I've got to get this one out because let me tell you, if you weren't paying really close attention to things, then this whole thing would just pass you by. And ever since that last status conference, you know, everything had been scheduled up to this point to have the May 15th status conference, the last one scheduled before the trial. And then in August, you know, you had late July, you had jury selection and the trial would start. I mean, that's how this thing was scheduled. So after the May 15th status conference, you know, you really weren't supposed to see anything until the trial. Well, let me tell you what, since that May 15th status conference, things are exploding in this case. But it's all behind closed doors, or a lot of it is. So if you weren't paying close attention, you wouldn't even realize what's exploding right in front of your eyes. And when I look across the board at the coverage of this, I mean, it's almost non-existent. A couple people have mentioned it, but it's insane. So what I want to do in this video is I don't want anybody to be left behind on this stuff. I'm going to take the case summary from May the 15th, the last scheduled status conference in this case. And then I'm going to go through a timeline, and I started out thinking I could get it all done one little page timeline. I mean, I almost I had to condense it just to get it in 2 pages. And there's more breaking news happening this very minute. So as I go through this though, I think it's going to tell a story. It's going to open your eyes to all the things that are going on behind the scenes. And we got to keep the heat on because they're trying to do stuff behind the scenes. And we know in this case, when things are done behind the scenes, they're not done in a fair way to the defense. So keeping it out there in the forefront is very important. And I need to be more, it needs to be more than me speaking out about this stuff. So, but before we get into any of that, we're going to dive right into this case summary timeline, what's actually taking place right now. I'm going to point out a bombshell that just happened that I knew was going to happen. Sorry, Daniel. But goodness, if this doesn't open your eyes to, I mean, there's no telling what's going on behind the scenes. We know some of it. We've sniffed out a lot of it, but there's other things going on that is worth our attention and going to dang sure be worth some people's attention out there. Let's roll. Okay, so I've put this timeline together just to give you some of the highlights of what's happened since that last March 15th status conference. Now, in the beginning of this video, I showed you Hippler's strong words to Ann Taylor to tell her that he'd be looking for her to file for a special prosecutor that would be brought in to do a special investigation into the leaks in this case. And we had been waiting for that. Now, on May 20th, 5 days after that status conference, Ann Taylor files the motion to continue the trial due to discovery, all the discovery that's yet to have been gone through, and because of that leak with Dateline and all the other minions out there. Then the very next day, there was a secret hearing with, we know at least Steve G, because his attorney Shannon Gray was the only other one listed on there, about the role of victims. Now, we all know that we haven't seen the Steve G media tour since that hearing, so we can guess what took place in there. But something happened, and unless you really pay close attention and you go back and you look at the case summary, this stuff never even hit the case summary, much less the court docs. But between May 21st, 2025 and May 23rd, 2025, there was something filed, and it never posted to the court docs at all. And that's what I talked about in a video the other day about the defense filing a secret ex parte filing with the judge. And the judge rules that a redacted copy is to be given to the prosecution. So we don't know what this secret ex parte filing is, and neither does the prosecution, as you heard in their motion of opposition, or their opposition to the defense's motion. But I went over it and I hit this part hard. But this is when it happened. Between May 21st and May 23rd is when they filed that ex parte filing with the judge. And again, it started off with the judge ruling that the defense had to give the prosecution a redacted copy. But then on May 23rd, 2025, the defense objects to a redacted copy for the prosecution. This is now on the case summary, which tells us that this happened between May 21st and May 23rd. Now, the defense on May 23rd also, as they object to giving the prosecution a redacted copy of that ex parte filing, the defense submits their offer of proof for their alternative perpetrators. Then we go fast forward into the future, 7, 8, 9, 10 days? And then on June 2nd, the defense files their 23rd supplemental request for discovery. We know that there must have been something very big in this supplemental request for discovery, because on June 3rd, the state responded with their response to the request for discovery by the defense. But then the very next day, way out of character for the state, they respond again to that request for discovery by the defense with a supplemental response. So that tells us this is something different than the other supplemental replies or supplemental requests for discovery. So this one has some implications to it. And then we know on the very next day, Hippler orders the defense access to sealed grand jury materials. Then the state files opposition to the continuance. On that same day, the judge gives that access. Then the very next day, the state objects to the offer of proof of the alternative perpetrators by the defense. It's just bam, 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 bam. That's not where it ends, though. On that watch how June 6th is, all right? So again, let's go through this. June 2nd, defendant's 23rd supplemental request for discovery. The 3rd and the 4th, the state freaks out, responds twice to it. The 5th, Hippler orders the defense to have access to sealed grand jury materials. Same day, state files opposition to continuance. Very next day, they file an objection to the offer of proof of alternative perpetrators. Same day, defense files motion for independent analysis of evidence. Same day that the prosecution files their objection to the alternative perpetrator evidence. Same day, defense files for an emergency protective order. Same day. I mean, this is June 6th, must have been just the craziest day for all of these attorneys that they've ever had, because on the same day, the state responds to the independent analysis of evidence. So the defense files it on June 6th. State responds to it on June 6th. They jumped right on top of it, probably because the defense filed for emergency protective order. Now, I don't know which happened first. I got it in this order, but I imagine it probably went something like this. Defense files the motion for an independent analysis of evidence. State responds to that motion. defense files an emergency protective order, probably to make sure that nothing happens to that evidence. That's what it looks like to me. But look at this. The same exact day, there is a stipulated motion to add additional trial exhibits. Now, stipulated means the prosecution and the defense are both okay. Now, it never says who was the party to want the additional trial exhibits. It doesn't say if it was defense or prosecution. And I wouldn't even put this on here if it wasn't for something that just happened. But 3 days later, the judge orders granting defense independent analysis of that evidence that was filed on June 6th. Same day, the judge orders conditionally denying admission of additional trial exhibits. That's interesting because he's denying conditionally the admission of the additional trial exhibits that both parties had stipulated to 3 days prior. But then on June 9th, the exact same day, Hippler orders staying order for defense's access to the sealed grand jury records that he had already ordered in favor of. So it's very strange how this is happening right here. But then on June 11th, let me show you this because this is important. On June 11th, 2025, old Pav here exposes Drunk Turkey and possibly Steve G for leaking evidence and having direct access to the law enforcement personnel that leaked it to them. Y'all remember this video. I didn't get as many views. I think they suppressed it. But y'all remember this video for those of you that seen it. This was posted by me on June 11th. Now, old Daniel, bless his heart, I hated to do it to him, but I mean, this is a very serious matter in this case, and he just came out and admitted that he had access to the leaker on his show. So what's interesting is when I posted that video, and I got it out pretty early because I wanted the defense team to know about this, and Pav's got a grapevine, through the grapevine, and it came fast. A little birdie whispered in my ear that video had been taken notice of by officials in high places, and they were already starting to move on that. So although Daniel, the next night in his live, he tried to come out and retract his braggadocious statements. Sorry, bud, it's too late. The wheels were already in motion on you as soon as you said that. So yeah, y'all should be looking for some interaction with those prosecutors pretty soon. But let's move forward. But keeping this timeline moving right along, just a refresh, June 6th, everybody was back and forth. June 9th, the order from the defense, order from the judge granting defense independent analysis of evidence. June 9th, order conditionally denying admission of additional trial exhibits. We don't know which party he denied. But also on June 9th, Hippler orders a staying order for the order that he had already granted for defense access to the sealed grand jury records. That one is in contention right now, and it needs to go ahead and be released. But then on June 11th, I exposed Drunk Turkey and possibly Steve G for leaking the evidence. Coincidentally enough, on the same day, June 11th, 2025, the defense team files a motion for access and fair investigation. That is for the special prosecutor. They just happened to file that the judge said he'd be waiting on the day that I exposed Drunk Turkey and his statements. And also on that day, the defense objected to Hippler's order, staying his order for the defense to have access to the grand jury materials. Very same day, defense objects to release of confidential work product. We're going to have to look at that because that is big right there, and I don't know why the judge would want release of the defense's confidential work product and who they want it released to. But on the same day, look at this, bam, bam, the same day the defense files access for the special prosecutor, June 11, 2025, the state responds to defense's motion for the special investigator. And that's where we're at right here, folks. So this stuff is like bam, 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 and nobody out there is covering it. It's amazing. But I thought this was funny in a way. Yeah. I wonder what the state's response to that motion for special investigator says. But what is this right here? Defense's objection to release of confidential work product. Why would they want the defense to release their confidential work product? And what is a confidential and privileged work product? Let's take a look at some things on that. Okay, so again, just to kind of refresh, we see on the 12th here, they let's see, order sealing defendant's amended exhibit chart. All right, so there it is right there. It was defense's amended exhibit chart that the judge has conditionally ordered against, and it was stipulated. So that's interesting. So it was the defense that filed that. That just popped up here. All right, 612, order sealing state's response to the special investigator. Order sealing defendant's motion for access. So this is the motion for access to the grand jury materials. And objection to the court's order staying the order that they already granted the defense access to those grand jury materials. So what is going on with that? And then right here was to seal the response for the special investigator. 611, defendant's motion for the special investigator. And on June 11th was sealed defendant's motion for access to grand jury investigation and for a fair investigation, which you can bet is for the special investigation into the leaks. Sealed defendant's motion for access and court order, independent analysis of evidence. Let's see here. Where is it at? Oh, right here. Objection. Sealed defendant's objection to release of privileged and confidential work product. See, there's no motion in here talking about access to defendant's privileged and confidential work product. So we have to learn about it later on with a sealed objection of the defendant's release to the privileged and confidential work product. Who the heck is the judge trying to get the defense to release their privileged and confidential work product to? Is it the special investigator or is it the dadgum prosecution? That needs to be put out into the open. They don't need to hide stuff like this. Let's talk about privileged and confidential work product. Now, I had somebody in my comments yesterday pointing out that you should never trust the AI overviews and never trust AI, period, because I oftentimes will go through the Google AI summation of things. And I did respond to that comment, but just to let everybody know, anytime that I go through the AI review from Google, what's good about Google is it references the articles that they obtain this information from. I always go through and read the articles and make sure that the articles align with the AI interpretation. And if they don't, then I read y'all the actual articles. But if they do, then I read you the AI summation. So I always verify it before I do it. Idaho law about work product refers to documents and other tangible things prepared by an attorney or an attorney's representative in anticipation of litigation. The purpose of the work product doctrine is to protect an attorney's mental impressions, conclusions, opinions, and legal theories from discovery by the opposing party. So there is a work product doctrine. It's not like attorney-client privilege, but it is actually a doctrine so that you can't see their work product. But key aspects of work product in Idaho. It's prepared in anticipation of litigation. The material must have been created because of the prospect of litigation. It's prepared by an attorney or their representative. This can include documents created by the attorney, their staff, or even third parties like consultants, as long as they are working under the attorney's direction and in anticipation of litigation. Documents and tangible things. The work product doctrine applies to various types of materials, not just communications. Protection from discovery. Generally, work product is protected from disclosure to the opposing party during the discovery phase of litigation. Distinction from attorney-client privilege. Work product differs from attorney-client privilege. While attorney-client privilege protects confidential communications between an attorney and their client, work product protects materials prepared in anticipation of litigation, regardless of whether they are communications or confidential. So they don't even have to be confidential. And examples are attorney notes from witness interviews, research memos prepared for trial strategy, drafts of legal pleadings, or communications between the attorney and an expert witness regarding the expert's opinion. And drafts of legal pleadings is sticking out to me right there because the ex parte filing that the prosecution would like to get their eyes on, that would be considered a draft of a legal pleading. Important considerations, waiver. The work product privilege can be waived if the material is disclosed to a third party in a way that suggests a likelihood of disclosure to a potential adversary. So this would come into play, it looks like, with a special prosecutor if they had to give that work product to the special prosecutor that was investigating, and they don't want that special prosecutor to divulge any of their confidential work product to their adversary, which is the state. Expert witness work product. While the drafts of expert reports are generally protected as a work product, the final expert report and certain related communications, such as those concerning the expert's compensation and the facts data considered, are discoverable. The work product doctrine is crucial for allowing attorneys to prepare litigation without fear that their strategies and thoughts will be readily available to the opposing side. So whatever this objection is that the defense is filing to the release of their privileged work product, they must have fear of their privileged work product falling into the hands of the state for some reason, and they should be able to do their job without fear of that happening. So we need to keep eyes and ears on whatever the defense is objecting to around this subject so that more travesties in this case don't happen right in front of our face when we can stop them by putting attention on it. Now, I've often had a lot of people in my comments and other content creators on YouTube say nothing that we do here on YouTube has any impact on anything. And I happen to disagree with them. I happen to believe that a lot of the things that we do here on YouTube has huge impact on this case. And I've seen it in real time more than once. So we will continue to put out the truth, put the focus on what needs to have the focus on, put the attention on what needs to have the attention on, and expose what needs to be exposed. Because once you expose something, I assure you, they think twice about continuing to move in the direction that they're moving when you put eyes on it before they do it. And there's a lot of stuff happening in this case. That is just through June 13th. The hearing isn't until the 18th. Something else I want to point out is I clearly pointed this out a while back, not because I know everything, but because it seems to be something that needs to be addressed. I have not seen yet the judge add additional time scheduled for this June 18th hearing. And I can't understand for the life of me why. Because when the judge initially quizzed the defense in the May 15th hearing about their schedule the day of June 18th and their availability, the defense said that they already had things scheduled and they couldn't start until a little afternoon. The judge clearly stated, well, I don't think that's enough time for us to get through the alternate perpetrator hearing. Then the defense files a massive motion to continue. The judge comes back with, the prosecution comes back with a half-hearted opposition to that motion to continue. That's about 20 pages. The defense's filing was 40. So that tells you everything you need to know right there. Little troll in my comments. But even with this motion to continue added to the June 18th court date that the judge already said was barely, if going to be enough time to hear alternative perpetrator evidence, they have not added any additional scheduling time for the hearing. So if the alternative perpetrator hearing was going to take more than a day and you were already cutting it short, you add a motion to continue that's a massive to it, but you're not adding any additional time to the hearing? What's going on? And all this other stuff that's happened between then and now, you know is going to be addressed in court, maybe in the closed hearing because we're not able to see it, but that adds additional time to that hearing. So until I see additional time scheduled on that scheduling order for this hearing on June 18th, then I'm not going to believe everything is on board, and you shouldn't either. But we got to keep vigilant on this thing and keep our eyes on everything because there's big stuff going on. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, when I'll have a video out here shortly about a massive injustice that I discovered yesterday in this case that proves everything that the defense has said, and that's why I don't believe the state on hardly anything, because the defense has clearly pointed out all of the BS in this case, and it's turned out to be a fact. And I continue to verify what they've said as fact in these documents. I'll have that to you shortly. Pavarotti's out.